Hello, this is Matt on the Moon Lambo channel. The SEC legal team just sent a document to Judge Netburn in the SEC vs. Ripple case, which resulted in attorney Jeremy Hogan of the XRP community stating, and I quote, "This is as crazy as it gets," end quote. Folks, the SEC is arguing to the judge that a former SEC director, Bill Hinman's Ethereum free pass speech in June of 2018 is official position of the SEC, specifically the Division of Corporation Finance. It is. Do you understand the implications of this? Well, I'm going to break down what I know to this point, but worth noting, that means that the SEC has argued that there's nothing from the SEC that's official market guidance. However, this is now official market guidance. It just gets more ridiculous from there. So I've got opinions from a number of attorneys, including attorney John Deaton and attorney Jeremy Hogan. And this just came out within the last, I don't know, how long has it been? An hour and a half or something like that. So I read this whole thing. I printed it up. I got some dead trees in my hands here. I believe it was 11 pages, not including the exhibit. So I highlighted the parts that I found to be most relevant and took some notes. But I'm telling you, like, I hope that you're prepared to have your mind blown, because this is truly bizarre. It's absolutely absurd what is being argued here, even for the SEC. But I do want to be clear at the outset, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice. And you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. You may recall that on January 13th, Judge Netburn found that in an official ruling that Bill Hinman's Ethereum free pass speech really was just his personal opinion. And also, as a result of that, all of the associated documents and emails that were distributed via SEC, the official email threads, those were not privileged because it was all part of what was just Bill Hinman's personal opinion. Well, understandably, the SEC didn't like part of that. They don't want the privileged information, that what they claim is privileged information anyway, to get into the hands of Ripple. They don't want that to be part of the trial at all. And so you got to kind of wonder, what are they trying to hide? What is so super duper secret that would destroy their case that they're fighting so hard to hide? Because this should have been a done deal, but they, after Judge Netburn made that her ruling, that declaration, the SEC legal team, they actually went to Judge Torres, the main judge in the case, and said, "Hey, we want to be able to have a response sent back to back to Judge Netburn." And Judge Torres said yes. And so the deadline for that was, I guess, 13 minutes ago. And they just made it just in under the wire. They sent it within the last couple hours, whatever it was. So this is completely ridiculous here. And here you can see earlier today, well, today for me anyway, the deadline was midnight for me, though I'm in Central Standard Time. So the deadline's their time. So it's 12:13 a.m. their time. My time, since it's Central Standard Time, happens to be 11:13 p.m. But so this morning, for me, it's this morning anyway. Attorney James Filan, member of the XRP community, he noted the SEC motion for reconsideration of the DPP ruling should be filed today. So that's what I was referencing a minute ago. This idea of, are these documents specifically surrounding the Bill Hinman Ethereum free pass speech, are they privileged or are they not? And the SEC's deadline was today. And Jeremy Hogan, here's a tweet from him at 7:18 my time, which would have been 8:18 his time, and for the court, because the court obviously is on the East Coast, it would have been 8:18 their time. And so Jeremy Hogan wrote the following: "I have to get my kids to bed. Don't forget that the SEC's motion for reconsideration of Judge Netburn's DPP ruling is due today. In federal court, you have until midnight, so that's 3.5 hours left. If they don't file it, come wake me up, because that would be strange." And they did file it, though. And so as soon as that dropped, I was like, oh, here we go. Can't wait to see what the hell's in this thing. And so shout out to James Filan and John Deaton's organization, Crypto Law, for sharing these documents. And let me just tell you this. I'm going to share with you some of the specifics from the document, but let me just kind of break this down before I even get into some of the specifics. So regarding the Bill Hinman Ethereum free pass speech of June 2018, the SEC has argued that Bill's part of the conversation via email is personal opinion, But the other people participating in this conversation with Bill are saying things in this conversation that are privileged. So yes, the SEC is arguing that one half of a conversation can be personal opinion, and as such is public info, having nothing to do with the the official policy decree from the SEC. But the other half of that same conversation can be privileged because it was part of the SEC's deliberative process with respect to Ether. And that's a quote. They say it's the SEC's deliberative process with respect to Ether. Now, this is incredibly illogical. To be clear, they're claiming that every SEC employee that was part of this conversation via email was participating in official SEC deliberative process, with the only exception being Bill Hinman. They say Bill Hinman was not part of the SEC's official deliberative process. How the hell can they justify this position? Well, spoiler alert, they don't. They just make the claim. But wait, it actually gets much worse and much more ridiculous than that, which brings us to most of what was covered in this document today. See, after the SEC finished arguing that nonsense, which is much of what it's been saying for a lot of the past year, frankly, hold on, let me make sure. I think I just lost my train of thought. I think it'll come back, though. I think I got it. So after the SEC finished arguing all that nonsense, they then proceeded to state that Bill Hinman's public statements actually could be relied upon as representing the views of the SEC's Division of Corporation Finance. Now note this important distinction. They're not arguing that Hinman's perspective is the official position of the SEC. Rather, they're arguing that it's the perspective of just one division within the SEC. As a result, the emails associated with the Hinman speech are privileged, they say. Now, presumably, the reason they are making this argument is so that they can make an additional distinction. They're saying that Hinman's speech is the final product, and that's public knowledge, but all of the drafts and communications that preceded the final product are privileged. Now, of course, you still have the question of how the hell this could be if it's really just Bill Hinman's opinion, but how do you have official SEC deliberations that just result in the public opinion, which was the final product, like the public opinion of Bill Hinman? It doesn't make any sense. And now, Judge Netburn has already ruled that the Hinman Ethereum free pass speech is fair game, and the SEC is not trying to change the judge's mind on that point. They're just arguing that all the additional emails and drafts of the speech that were shared internally are privileged. It's also worth noting that Bill Hinman, he swore under oath that his Ethereum free pass speech was just his personal opinion. And now the SEC is arguing that's not true. That it's the official position of one division, one of the divisions within the SEC, the Division of Corporation Finance. Of course, now, if that's true, then the SEC did provide market guidance, which the SEC claims it has not done. If the SEC gave market guidance, and it clearly did, then that strengthens Ripple's case and weakens the SEC's case. It's absolutely incredible the degree to which the SEC is utterly inconsistent with its own arguments. Those assets will argue, they will argue whatever they think will benefit them in the moment, even at the expense of logic, consistency, and justice. They just don't care. And don't be surprised if they're going to end up arguing that since it's just the official position from one division of the SEC, it's not official SEC decree, don't be surprised if they try and make an argument like that. That won't surprise me in the least, I'll tell you that right now. So now I'm going to highlight just some parts of this. Here, I'll start with this, what I'm highlighting on the screen right now. Let's start with this. So this is from the SEC writing to Judge Netburn. This really grinds my gears, folks. And it burnt my biscuits and my vegetables. They are steamed. This really steams my vegetables, in fact. The court found that, quote, emails concerning the speech or draft versions are neither pre-decisional nor deliberative agency documents entitled to protection, end quote. So that's what Judge Knepper found. Under the deliberative process privilege, or DPP for short, and ordered the SEC to produce Entry 9 and other documents, quote, previously withheld based on the privilege that would be inconsistent with this order, end quote. And then it continues a little bit further down to this part. And it just gets more and more wild, folks. Reconsideration of this aspect of the court's decision is warranted because the court based its decision on a single document relating to the speech, one that defendants chose to highlight for the court, and did not consider the 67 other emails attaching drafts of the speech that were before the court on defendant's motion. These additional documents, along with other matters available to the court and described below, demonstrate that the speech was not, quote, merely peripheral to actual policy information, end quote, and was in fact, quote, an essential link in the SEC's deliberative process with respect to Ether. You folks buying any of this crap? Is anybody buying any of this crap? I'm going to hop ahead to Attorney Jeremy Hogan's comment in just 1 second, so sit tight because you're really going to enjoy that one. But he made it very clear that agree to which this is crazy. His words, not mine. Oh, no, mine too, actually. I'm going to use those two. Where's the next part? Oh, right here. Yeah, I just want to highlight this sentence right here. SEC regulations provide that Director Hinman's public statements could be relied upon as representing the views of corporation finance, the division he led. Folks, Judge Knepper already said no. She said no to this already. She said no, this is clearly just Bill Hinman's personal opinion. Because look, from her perspective, and she made this clear, if it were the case that it weren't just personal opinion and it were official decree from the SEC, then she wouldn't want all of those associated emails, obviously, to be to share, because then it would be privileged. But she's saying, obviously, it's just the personal opinion of Bill Hinman. And so whether or not you agree with that, it is what it is. All right, let me get ahead here. What do I highlight next? This might be it. Is this the really fun part? This is the really fun part, I think. Can't believe this, folks. Oh, yeah, here we go. This is it right here. So here's the tweet from attorney Jeremy Hogan, and he simply wrote the following. I'm reading it, but can't quite believe it. Now, the speech wasn't Hinman's personal opinion at all, but intended to convey the Department of Corporation Finance's position on digital assets? In the legal world, this is as crazy as it gets. The Ripple lawyers must be chomping at the bit. That's the tweet from attorney Jeremy Hogan. Yep, I cannot wait to see what the hell Ripple's legal team has to say about this, and they're going to shred this nonsense. Because look, I can't tell you, and I admit this every time when I'm talking about legal stuff, like, I don't know what the legal implications are of all of this. I'm just speaking as a regular dude here, and I'm telling you, this is utterly illogical. The degree of ass-hetery is endlessly impressive. This isn't logical. You don't need a law degree to see that the logic doesn't follow. I just don't know from a legal perspective what's likely to unfold. But damn, this is stupid. S-T-O-O-P-I-D, stupid. Here's a tweet from attorney John Deaton on this. Classic case of wanting to eat and have your cake at the same time. That's also quite true. Here's a tweet from an attorney within the XRP community who is named Bill. And Bill stated the following. And it was he sharing the same section? No, he was sharing a different section here. Yeah, here we go. Here, I'll just read this first, and then I'll share his tweet. Shows that Director Hinman and other SEC staff used the speech to provide public guidance as to how corporation finance would apply the federal securities laws to offers and sales of digital assets, including Ether. Indeed, SEC regulations provide that Director Hinman's public statements could be relied upon as representing the views of corporation finance, the division he read. So that's part of that I already read to you. But that's what Bill shared here, and then Bill wrote the following. So now the SEC says that not only was Hinman's speech used by SEC staff to provide market guidance, but that by SEC regulations could be relied on as representing the views of the SEC's Corporation Finance Division. So not a personal opinion, a moving feast. So let's pause to think about that. If this is official market guidance from the SEC, and Ripple's supposed to be able to, that would mean that Ripple's, of course, every participant is supposed to look at this as guidance. Well, XRP is better suited for Bill Hinman's guidance than Ethereum is. No kidding. Well, for obvious reasons, not the least of which is the fact that there was no XRP ICO, so how about that? Anyway, Bill continues. So now we know there are 3 types of speeches in the view of the SEC. Mere personal opinions, views of an entire division of the SEC, and the SEC's formal agency position. Is that clear enough? Lots and lots of clarity. And he's got little laugh emojis. Feeling good about fair notice. The SEC has vacillated between whether the speech was a personal opinion of Hinman and now reflecting the position of the entire division he led, depending on what suits it at a given moment in the litigation. And so that's why, the part that Jeremy Hogan shared here in his tweet too, it reads as follows. As reflected in its text. Well, actually, let me read the headline first. Director Hinman delivered the speech at the Director of Corporation Finance to communicate Corporation Finance's framework for evaluating digital asset offering. Bam. Can you believe they're writing? They're acknowledging it is market guidance from a division within the SEC. But they are distinguishing, and this is why we'll see to what degree this legally has an implication, but they're distinguishing between just one division's official opinion versus the whole SEC. So what does it take for the whole SEC to have an official position? Does that mean all divisions of the SEC, they all have to come together and say, this is our official position? Is that how it works? Has it ever worked like that in the history of the SEC? I've not heard anything like that. If that's the case, you let me know, but this seems completely freaking absurd. It's completely mind-boggling. And so then it reads, as reflected in its text, the speech was intended to communicate the general approach used by corporation finance in evaluating whether digital asset offerings may be considered securities offerings, and to invite the market to communicate with corporation finance staff about these issues. It's astonishing, folks. And then Attorney John Deaton retweeted that little short Twitter thread from Attorney Bill. And Attorney John Deaton wrote the following. I've said for a year the SEC lawyers are 100% transactional. They will say whatever it takes to win a particular argument, no matter how inconsistent that argument is with other statements or arguments they've previously made. Oh yes, that is most certainly true. And I may not have it pulled up here, but I don't know. I can see if I can find it real quick. If not, it's not the end of the world. I can just describe it. But there was that's not what I wanted. I want to click on Crypto Law's Twitter profile here. But if I can find it at the top here, then I'll share it with you. But yeah, here we go. This is what I was looking for. This is from John Deaton's Crypto Law Twitter account. So here you go. Hinman's declaration on June 23rd, 2021 in support of motion to quash subpoena for him to be deposed by Ripple's lawyers. And here's the image that was shared. This is from Bill Hinman. This is what Bill Hinman wrote. I'm just going to read the first part. It's on your screen if you want to read the whole thing. But he wrote in part, the speech was intended to express my own personal views. Folks, that's Bill Hinman's own words. The speech was intended to express my own personal views. Now the SEC is saying, nope, that's official decree from one division within the SEC. They're saying, no, that's not true. Absolutely astonishing what's happening here. Is this not mind-blowing? Can you see why Attorney Hogan wrote, this is as crazy as it gets? Flabbergasted. Really grinds my gears, folks. That's what I got for now. I'm sure there's going to be more to say about this. I can't wait to get additional feedback especially after the attorneys in the XP community have had some time to digest this a little bit further. But wow, talk about completely cray. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.